It is incredibly damaging for a criminal defendant when he is identified by a witness during trial. So in almost every criminal trial, the prosecutor will try to set up a scenario like this. He'll put the witness on the stand. He'll ask the witness what happened. And the witness will say something like, "I was threatened by a man with a knife." And then inevitably the next question the prosecutor will ask is, "And do you see that man here today?" And the witness will say, "Yes, I do." And he'll point at the defendant and say, "That's the man right there." So I can't emphasize enough to my clients, if this is going to happen, an acquittal is going to be extremely difficult after that. Now, the court doesn't want this situation to play out for the first time at trial. What they want is an out-of-court identification done that can be contested by defense counsel if it's overly suggestive. So if a witness reports a crime to the police, or the police talk to a witness during an investigation, and the witness has encountered the suspect for the first time when he observed the alleged crime take place, the police should do some sort of lineup or photo array or even a show up to get the witness to identify the defendant or the suspect outside of court. And then that should be presented to the defendant and his lawyer prior to trial so that it can be contested at trial or before trial if necessary. The defendant should not be identified for the first time when he's sitting at the defense table during trial. But it can be done when there is good reason, and those are the court's words, good reason to do the identification for the first time at trial. So first of all, if it's going to happen at trial, the identification is going to happen for the first time. The prosecutor has to give notice of this to the defense counsel in advance, and the defense counsel can object to it. And like I said, there has to be good reason, and the court gives a number of scenarios where there's good reason, but what they really boil down to is the witness must be familiar with the defendant prior to witnessing the defendant commit the alleged crime. So they give an example of a domestic assault and battery. Obviously, the victim and the witness know each other, and the identification at that point is simply confirmatory. So I've written a blog post on this with more detail and citations to cases, and I'll put it in the description below.